So this is just taking what the law says to put it in a slightly more digestible format for people to be able to, have this on a couple pages. So when you're trying to understand, retailers will want to have this too, but it's going to be easier for people who are actually manufacturing the products to use for guidance in making the products. I will be able to share this with anybody who wants this once I have it completed. We have a compliance guidance document for edibles, and I want to update that guidance and incorporate this into it so that we've got a compliance guidance that's good for both types of products. So starting at the very start of this, the retail registration, most of you all on this call have already registered your retail business. It's, if you're going to be selling products directly to the end consumer, you do have to have the regulated hemp products retail facility registration. It's an annual registration, $1,000 annual fee, and it's related specifically to the location. It's not transferable. If you ever sold your business, the new owners would have to get their own registration. And if you moved your business, unfortunately, there's no way to transfer it from one location to another. Okay, the THC limits in law for inhalables are the same as the THC limits in law for edibles. This is going to make it very challenging. It's already challenging for edibles, but it's even going to be more so challenging for the inhalable products to get those limits under control in the products. And it's going to require some thinking outside the box in some cases. And I will tell you that VDACS is going to be a little more accepting of some of the ways of thinking out of the box for these inhalable products, especially something like flower, than we were for edibles. The best example that I can think of is when it comes to, you still will not be able to have within the same package two separate packages of things. So for folks who are thinking of putting THCA flower with a pack of CBD isolate in a pouch or something, that's still not going to work because you still have two separate packages there. You're going to need to have it all together in the same package. But if you had the best example I can think of this, it's not something that I'm suggesting is a great idea. But if you were to take THCA flower and coat it with a bunch of CBD isolate, if that's what we found in the package, if we collected a sample to have it tested, we're not going to do anything about that. It is what it is, and we're going to test everything that's in that package for compliance with the law. So there is going to be a little more flexibility. You just won't be able to put a package inside a package and call that good. Obviously, with your vapes, liquids, oils, well, any kind of liquid vaping product, that'll be a little bit easier to manage. It's just with the flower that you're going to have a struggle to make it compliant. There are ways to do it, but there's going to be a little more challenge to make that compliant than it was for edibles. So, all right, child-resistant packaging is still going to be required for any product, any inhalable product that has any level of THC in it. So it has any THC in it, it has to have child-resistant packaging. And just like for edibles, if it has more than one serving, you're going to need to have that package resealable. As far as the labeling goes, there's less labeling required for inhalable products than there are for edibles. First thing on the list here for labeling is all the ingredients contained in the substance must be listed on the label. And I'm not going to read out the sections of code. They're right here on this guidance, which, if you request a copy of it, you'll have it. The label has to state the amount of substance in a single serving. And for this one, you're going to want to have the amount of substance in terms of volume or mass, just like you have to have it for edibles, because the amount of product together with the amount of cannabinoid in there is how we can determine percentages of things if we don't happen to have the COA. So, for example, if we collected information on a particular, well, I'll just think of a random example, a vape pen, for example, and the QR code doesn't work. So we don't get to see the COA during our compliance review, but we're still going to review the product with whatever information we have based on what's on the label. So you need enough information for us to be able to make a determination. The next item on labeling is the total percentage of THC in the substance must be declared on the label. And just like with edibles, we're not talking about the general Farm Bill less than 0.3% THC. We're talking about the total percentage of THC in the substance. And you'll need to, make a determination of that so you can have that on the label, just like for edibles. You also have to declare the number of milligrams of THC in the substance on the label. The number of milligrams of THC contained in each serving must be declared on the label. And if the product has any THC in it, then it has to have the statement, the age restriction statement may not be sold to persons younger than 21. And we take statements that are similar to this, but we do like to see the statement phrased from, what the retailer's actions are. For example, this says may not be sold to persons younger than 21. If you shortened that up, may not be sold to under 21, that would still be acceptable. We really do prefer that it says it controls the action of what the retailer is doing versus what the purchaser is doing. We may give a pass on a product that comes from somewhere that says may not be purchased by younger than 21, but that's not really where the focus should be. It should be on who's selling it, not on who's purchasing it. All right, let me move to the next one. Okay, just like for edibles, inhalable hemp products must be accompanied by a COA from an ISO 17025 accredited lab that states the total THC concentration of the batch from the substance from which the substance originates. And because it has to have the information from the batch, you also have to have a batch code on the product, and the batch code needs to be able to be matched to the COA. And this topic right here brings something forward that I've had several questions on already, and I'm going to go ahead and address it now. And there may be some additional questions about this, and I will definitely understand the questions. When you are growing hemp, you have to have you have to legally show that your crop is legal, and you have to have testing to show that crop is legal. And so you have a COA that says that the product or the plant material from your field was in accordance with the hemp law. So, that's a COA from your field testing. And I've had multiple people ask this question, can we use that COA for our product? And the answer to that question is no, you cannot. I mean, you can do it, but it's not going to work, because part of what we're going to be doing is testing product. And for those of you who grow hemp and produce it into a product, you will already know that the COA you have from your field test is not going to show what that product is in its final packaged form. So those of you who are already in the business of growing it or purchasing, dry hemp or hemp that's already been cured and ready to go, you're already going to know that the COA from that field test is not going to be what's in that final package. So, based on your own knowledge, you would know, you should know that it's not going to work to have that COA go along with your finished product, because there's a lot of stuff that happens to hemp from the time it's tested in the field to when it is finally slipped into its final packaging and labeled and ready to be sold. So I'm happy to take additional questions about that. And for those of you who didn't think of that question before, you're probably surprised at that piece of information, and maybe it might make you mad to hear that. And if I were in your shoes, it might make me mad too. I mean, there's a lot here to make people mad. So I will totally get it if that makes you mad, but I'm just explaining to you what we're going to be expecting. Okay.
There has been a few questions that popped.
Yeah, sure.
So will post-harvest COAs be, just to clarify, post-harvest COAs are going to be necessary? Or will they?
To show where the hemp came from, that the hemp is legal, that is something you should maintain in your records, but it's not something we would ask for unless there's an issue. So, you would maintain that. You would be responsible for maintaining that information in your own records in case it was a question of where you got your hemp. For example, when I start up a list for inhalable products, I'm not going to ask for all that documentation. I don't think. I haven't devised the MOU that I'll have to go with inhalables. But right now in this time, I'm not thinking I'm going to be asking for all that post-harvest testing. I'm just going to be asking for the COAs on the finished product itself. So, the post-harvest testing, I'm going to just, in most cases, I'm going to trust you that you're getting your products from legal sources, because it's just a different thing from the inhalables from the edibles on this part. So if I change my mind for some reason and start asking for that, I'll apologize in advance. But right now, I don't see myself asking for that in the process of getting products on the list. Any other questions on this?
Does this include cartridges and vapables?
You mean the law itself? Yes, the law includes all inhalable products. So it would be anything that is introduced into your body through inhaling. So it'll be smokable flower and vape pens, disposable cartridges, vape pens, any inhalation of any sort to get hemp extract, hemp compounds into your body. Yes. Anything else right now?
There's other questions, not necessarily pertaining to this particular topic, that I'll circle back to.
Okay. All right. And just like with edibles, no person shall offer sale a regulated hemp product that depicts or is in the shape of a human, animal, vehicle, or fruit. No person shall offer sale a regulated hemp product that bears any significant likeness to another manufacturer's product. And that's the trademark issue. I don't think there's going to be that many people trying to use a trademarked thing with inhalables, but maybe it has happened. I just haven't looked that closely at inhalables until recently, but you can't do it with inhalables either. So then getting into the THC limits, I've kind of already covered that, but just to reiterate this and to also talk about total THC. Total THC with inhalables has the same meaning as total THC with edibles, and it includes the combined weights of delta-9 THC plus all isomers of delta-9 THC, which would include delta-6, delta-8, delta-10, delta-11, any other isomer you can come up with that has the same chemical formula as delta-9 THC. But the thing that has thrown a lot of people off is that in Virginia, for both edibles and inhalables, total THC does also include the adjusted weight of THCA. And THCA is the precursor to THC. It's what THCA is before it becomes THC. And this has been the case since July of 2023. Total THC includes THCA. So, for a long time now already, I've been telling people that THCA flower does not meet the legal definition of hemp in Virginia. I've told, I don't know, countless numbers of people that THCA will eventually get you in trouble if you sell it long enough, because it meets the definition of marijuana in Virginia due to the definition of total THC in Virginia. So, nothing has changed with how total THC is defined. It's in our law that it includes THCA. And then I've got a little information here on how you get that adjusted weight of THCA. And I have a formula on the guidance too for anybody to just plug the information in. And then the total THC has to be expressed as a percentage by weight of the combined THC waste in the product. This is another thing that I wanted to make sure that people understand. The THC percentage, it's not by dry weight for the consumable regulated hemp products. So both for edibles and for inhalable products, it's by the weight of the product, not by dry weight. So when you send your samples in for testing, for example, for I'll just mention the THC beverages, or for your vape liquids, you're going to request the percentage by weight, not by dry weight. Okay, and just like for our edibles, inhalable hemp products may not contain more than 2 milligrams of total THC per package, unless it also contains an amount of CBD that is at least 25 times greater than the amount of total THC per package. And as the law stands right now, there is no limit to the size of the package. And just like edibles, I used a silly analogy when talking about this limit, the existence of no limit. The limit of 2 milligrams per package could be in a package size, the size of a marble or the size of a 50-gallon drum or a milk truck tanker. There's no size limit on that package. Okay. Just like for in edibles, there is part of the law says you cannot have synthetic derivatives of THC in your products. So that's going to rule out HHC, THCP, and all those other synthetic cannabinoids that people have wanted to put in products, and that they still are in products everywhere, but they're not allowed to be in products in Virginia. And that's per the Virginia Consumer Protection Act. This piece of law, if you read the hemp law, you're not going to see this in the hemp law. It's in the Virginia Consumer Protection Act, and I've got the part of law that it's in right here. So this section of the guidance gives you a visual of how to do that calculation, so that you can, look at your COAs and determine what the total THC is if it's not already stated on your COA. I think most COAs have started to combine the isomers of Delta-9 on there. A lot of them have. I've seen a lot of them combine them, and I've seen a lot of them combine them and add the adjusted weight of THCA. They don't all do that still, but a lot of them do. So, but if they don't, you have the ability to do the calculation yourself and make that determination of the total THC. Okay, and then next, I am going to show you my mock label that I just put together today. This was my art project this morning. I don't know if y'all think this looks good or not, but it was my fun art project, trying to put together a visual of what information would be required on a inhalable product. I only have this one here that's for a vape product. I also want to try to make a mock label for a pre-roll to give you an example of what it would, one would look like for a flower product. So on the left-hand side, there are elements that are required to be on the label. On the right-hand side are best practice and maybe required by another part of law, not the hemp law. And so the ones on the left-hand side under required, those are the ones that would get you civil penalties if you don't have them on the label. If you look at the pieces of law in the hemp law, Title 3.2, Chapter 41.1, Industrial Hemp, Article 4, it does not require that you have your company name on the label, which is a little surprising. That's one of the things that is not in the law, and it's kind of surprising that it's not, but it doesn't require that the company be listed on the label. But obviously, anybody who's making these products is going to want their company name to be on here. You're also not required by that law to have the name and address of the manufacturer or distributor. It doesn't say it in the law that you have to have that. But obviously, you as the manufacturer would want to have that on your product. Net quantity of contents is not required by the law, but we kind of need that to be on the product. It would not get you a civil penalty to not have it, but if we couldn't make a determination on some of the other aspects that we need to evaluate, it would be problematic to not have that information. And also, net quantity of contents is something that is required by other parts of the law. When you get into weights and measures, weights and measures has broad authority over all types of packaged products. I don't know if there's any manufacturer here who has had their products examined by somebody from weights and measures, but if you haven't, you probably will at some point, or you may at some point, especially if these, if years go by and products become more accepted by everybody and they're just commonplace, which I wish that was sooner rather than later. Weights and measures would get involved in making sure that you're doing the right thing. Weights and measures is all over the place. They evaluate every kind of product you can imagine, and they have jurisdiction over packaged products of all types. So you want to have this on your product. Just for the biggest part, though, on the left-hand side where it says required, those are the things you really have to have on the label because the law states it specifically. That's the age restriction statement, the ingredients list, the amount of product in a serving, THC per serving, THC per package. You would need to have, even though the law doesn't say you have to have the amount of CBD in the package, if you've got THC in there, the requirement is to have 25-1. So you're going to need to have the CBD listed on the package to demonstrate compliance with that part of the law. And then percentage of total THC, all those have to be on the package. And then you have to have the law states you have to have a certificate of analysis that accompanies your product. And we're going to do the same thing with inhalables that we do with edibles. We have no issue with a working QR code that reasonably takes us to the certificate of analysis from an ISO 17025 accredited lab. And that is being done by a lot of different ways. Some people will have a website that holds all the COAs with a link to the batch of the COA. Others will take it directly to the COA. That works well for a small manufacturer who only has a few batches of product out there for sale anyway. But when you have these COAs available to us, they do need to be the full COA. And, we're getting in the habit, have been for a while in the habit of verifying that the COA is a valid COA, that it is coming from the lab, that it's presented as coming from, because I doubt there's folks on this call that have done such a thing, but we have encountered numerous fake COAs in evaluation of edible hemp products, and I anticipate we'll continue to encounter those as we begin to regulate inhalable products. Some are very well done fakes, and others are just so fake that you'd be dumb to not recognize it as a fake.
Wow.
So it's just been very interesting, because I am really good with making PDF documents and really good with documents in general. It's not what I do for a living, but I am pretty good with it. I have ways of detecting when COAs are not legitimate, either just outright by looking at it and examining the PDF or the document where it is, or by calling the lab. I've done that many times too. I call the lab and ask, hey, can you verify this certificate of analysis came from your laboratory and tell me what information you need? I'm not asking for your customer's information. I'm not asking for you to divulge anything you're not legally allowed to divulge, but I want to know if this COA came from your lab. And as somebody who has worked in a laboratory before and understands confidentiality, I have no problem being able to verify what I need to verify in order to know the COA is legitimately from that lab. Because having worked in a lab that also does not want information generated by the lab that I work from, I did not want people to take results that look like from my lab as real results when they weren't. So labs are going to be able to verify in some form or fashion that it's a legitimate COA. I didn't need to run through all that speech with you all, but I just got on a little roll there because I've been pretty surprised by the gall of some people. Let's just put it that way. Okay, so that is all of the information that I had to share visually. So I think I am ready for questions of all sorts.